A huge win for gun owners yesterday as the stay on the Nguyen v. Bonta case was lifted. This was the law preventing you from purchasing more than one firearm in California in a 30-day span. It happened in a little bit of an unprecedented way as well. Let's talk about it. Hey everybody, welcome back to the channel. That is right, we got some shock waves going through the Ninth Circuit Court as we're seeing a little bit of an unprecedented thing happen with the Nguyen v. Bonta lawsuit. Here to talk us through that today is Costas Moros. He is an attorney at Michelle & Associates. A lot of work on these cases that you're seeing moving through the court system for CRPA. Costas, thank you very much for coming on with us.
Thanks for having me again, Kevin. It's been a minute, but good to be back.
Yeah, absolutely. And for a good one as well. Obviously, we got a good order or decision, from the three-judge Ninth Circuit panel on the Nguyen case. But before we get into that too close, can you go ahead and just remind us, what is the Nguyen v. Bonta case and how has it come up through the court to get to the Ninth Circuit?
Sure. So the Nguyen v. Bonta case is pretty straightforward. California has a law that limits gun purchases to one gun per 30 days. That used to apply only to handguns. Now it applies to all guns of any kind. So if you're new into shooting and you want to buy a pistol for home defense and maybe a shotgun for some skeet shooting or hunting, you can't buy both at the same time. You have to buy one or the other, then wait 30 days and then buy another. And that also means, by the way, that you have to pay double the droves fees, which are almost $40. So it's not nothing, in a state that now has this 11% tax and guns are already expensive. Adding an extra droves fee is itself a burden, plus, of course, the 30-day wait between each purchase. So the district court ruled it unconstitutional through a final judgment, by the way. And but then the Ninth Circuit motions panel stayed it, and we see this all the time in the Ninth Circuit. There's a win at the district court, but the Ninth Circuit immediately stays it. And so we are denied relief until it moves through appeal. But as I'm sure you're about to get to, after oral argument the other day, 2 days ago, yesterday, the Ninth Circuit panel who heard oral argument actually revoked the stay. So now, as of now, you can buy multiple guns at once. You still have to do the 10-day wait, but you can dross them all at the same time with one background check and pick them all up 10 days later.
Well, straight to the punchline there, I guess, and I want to dig into that a little bit deeper. This is an FPC and a Second Amendment Foundation lawsuit, but CRPA did participate. CRPA put in an amicus brief for this, and I just wanted to read, as we got to the Ninth Circuit, the participation and a little bit of the argumentation here. This is actually from the introduction. Jacob, if you could pull this on the screen. It says this: some cases may present challenging constitutional questions, but this is not one of them. The district court and appellees are undeniably correct that there is no historical tradition of limiting the number of firearms a law-abiding citizen may buy at one time. The state has no relevantly similar historical laws in its support, and its interest-balancing arguments pertaining to the fears about gun trafficking are not only wholly irrelevant under Bruin, but are also nonsensical. It is hard to imagine that many illegal gun traffickers are going to source their supply from licensed dealers in California, a state where guns are more expensive than any surrounding state, where every sale requires a background check that adds nearly $40 more, and where expenses will soar even higher when the newly adopted 11% excise tax on firearms sales take effect in July. Buying guns from California gun stores to resell them illegally makes about as much sense as a liquor seller sourcing their beer supply from an overpriced concession stand at SoFi Stadium. And funny remarks aside, it is a compelling argument. We also saw some compelling arguments from the appellants in the oral arguments that happened, like you said, just a couple of days ago. I wanted to actually, Jacob, if you can, go ahead and hit this clip as well.
Under the state of California's rule, I could buy a gun to protect my store or my house, but I couldn't buy one for each, correct? And I'd have to wait 30 days.
That's right, Your Honor. You would have to wait 30 days from when you purchased your first firearm to getting.
So with that understanding, if the core right the Second Amendment is trying to protect is self-defense, then it seems to me that the law here is impeding that core right. There are other ways you can attack straw purchasing and bundling guns. I mean, I understand the state's interest in that, but in the hypothetical that Judge Forrest raised, I mean, that seems to be core Bruin conduct, the ability to defend yourself with a firearm either in your home or your place of work. How do we get around that in this case, unless you can point us to a historical analog?
So I guess, Kostis, there were some compelling arguments that we saw from the oral argument on the plaintiff's side. You also kind of saw the state's attorneys just really not perform that well, although in his defense, he has to defend something that's kind of indefensible here. What were your thoughts on the oral argument? And then kind of as you were getting into, were you expecting an order to come out just 2 days after the oral arguments happened?
Well, to take the second question first, no, because this hasn't happened before that I can recall, where you have essentially a stay in place and an oral argument go, I guess, so poorly that they revoke the stay. Usually what happens in these cases is, even when the government gets a stay, even if the government ultimately loses, you have to wait until that appeals court ruling, which could be 6 months, a year, or more later, before it's revoked. I mean, in New York, the Second Circuit, for example, had placed a stay on the plaintiff's win over their sensitive places case, including their vampire rule that blocked carry in all private businesses. And even though the Second Circuit ultimately struck down the vampire rule, they left that stay in place for over a year. I'm not sure if it was over a year, but it was a very long time until they struck it down. So it's unusual to see, and I wish we'd see it more, for a panel to tell the government, you know what, you don't deserve this stay we gave you a few months ago. The plaintiffs deserve relief now because these are constitutional rights at issue, and they shouldn't be delayed just because of some, deference to the government. Because they did so poorly at oral argument, because they couldn't answer basic questions about the Bruin analysis, it was very appropriate and proper for the Ninth Circuit to take away the stay and let the judgment go into effect while they're writing their opinion. And I hope we see this more often. I hope this is a sign of things to come.
Yeah, so a little bit unprecedented, but hopefully a little bit of a trend setter. You got a stay that is removed by a 3-judge panel just 2 days after the oral argument, and I think that was a great summary of the panel, just basically telling the state, hey, you don't have your arguments are poor, you don't have the right to have this stay. Something else that was discussed during the oral arguments I thought was pretty interesting. I was wondering if you could touch on. They talked about ancillary rights. Jacob, before we get into it, could you go ahead and roll this clip?
Curious about how the state had settled on that time period, but do you believe that the Bruin analysis applies? In other words, that this regulation falls within the plain text of the Second Amendment, and then we look to a historical analog?
That's correct. That with the text and history standard that the Supreme Court has set out would apply here, and it is plaintiff's burden to show that it is at the first step that it is presumptively protected by the Second Amendment, and in this case they haven't done so because this is a acquisition of firearms, and if we just purely based on the text of the Second Amendment, it doesn't mention anything about purchasing. It's keeping and bearing, and the Supreme Court has stated that keeping and bearing refers to possessing and carrying.
But we've addressed that issue in 2 cases that I can think of, Tejera and B&L Productions, and described acquisition as an ancillary right. So how does that affect the analysis?
So that's correct, Your Honor. It is an ancillary right, and as an ancillary right, as B&L Productions states, it is there is some protection for ancillary rights, but it's a plaintiff's burden to provide evidence that any regulation that touches on ancillary rights would have a meaningful constraint or impair an individual from being able to exercise their core Second Amendment rights of possessing a firearm for self-defense. And in this case, we have plaintiffs that already have firearms, and they can't purchase a firearm and just have to wait 30 days before purchasing another one. So they are exercising their core Second Amendment rights. There's no dispute about that.
So, Kostis, I guess my question is, what is the difference between rights, I guess, as the court should see it, between constitutionally protected rights and ancillary rights, because we've dealt in so many cases with the argumentation that the burden of proof for a law to be constitutional under Bruin is on the state. And what the state's attorney here is arguing is that because this is an ancillary right, which I'm sure that there can be more discussion on, the ancillary right portion, the burden of proof of constitutionality is on the plaintiff. So can you go into ancillary rights a little bit and why the distinction is there?
Sure. So in the Second Amendment context, and I'm going to steel man this for a second and argue it from the government's perspective. What they're saying is that the Second Amendment says there's a right to keep and bear arms. It does not say there's a right to purchase arms or to otherwise acquire arms. However, as the Ninth Circuit has acknowledged in a couple of cases, the right to keep and bear arms would be meaningless if you can't acquire arms. So what they're saying is there is this ancillary right of acquiring arms, but it isn't as expansive as the right to keep and bear arms. So as long as there's some reasonable way for you to get firearms, your ancillary right has been honored and the government can otherwise restrict it. So that's their side of things. My side of things is that there's no such thing as a Second Amendment ancillary right. What Bruin said was that we judge gun laws, anything that even implicates the Second Amendment right. It doesn't say anything that totally destroys your right to keep and bear arms. It says anything that implicates the Second Amendment right, which purchasing does, has to satisfy the historical tradition of firearm regulation. So that means acquisition, use, whatever else, even no matter how unimportant the government thinks it is, if it involves you keeping and bearing arms peaceably, then you have to satisfy the historical tradition. And what the historical tradition is that there has never been a limit on acquiring more than one firearm at a time. Now, the government below made the historical argument that it didn't come up at oral argument yesterday, but they had argued in their briefs that, well, in the founding era, guns were this artisan product that was hard to make. So it'd be pretty uncommon and unusual for anyone other than the government to buy multiple firearms at once. They were expensive. They took a while to make. Maybe that's true, maybe not. There's arguments on both sides, and I think the plaintiffs made a compelling argument that that wasn't true. But even if it is true at the founding, by the 19th century, you had Samuel Colt, you had Winchester, you had all these companies that did mass produce firearms. So whatever was the case in the founding, by the 19th century, guns were mass produced. They were available in the Sears catalog. You could mail order as many as you want. And even with that dramatic technological change, no state law, no federal law, no even local ordinance that I've seen said you can only buy one firearm a month or one firearm, whatever the period of time. So to the extent dramatic technological change happened, it happened 150 years ago or more, and yet no laws appeared at that time that would justify the modern regulation.
Well, and I guess the arguments weren't necessarily compelling because the state's attorney did make that argument and they issued the order to remove the stay regardless. I'm kind of curious, guys, couple things to check out in the description below. First of all, we do have a sponsor for this channel. It's the Police Credit Union. There is information on them in the description below every single video. Go ahead and check them out. I want to direct you to them. Money is an issue these days, so you want to make sure that you're keeping it with the right company. Go ahead and check them out. They offer some benefits to the channel or to CRPA members. Can be a great way to go these days. And guys, in the comments below, let me know if you could go back to a history in time. Would it be that time period where you could purchase as many firearms as you want through the Sears catalog? We're trying to get the algorithms to help us out these days. Let us know. I think since Kostas just mentioned that, it's kind of risen to the top of my list. But I guess, Kostas, as you're looking forward here now, and I guess we have a couple things. So what's the outlook for Nguyen as we've seen the stay lifted? So, I mean, you've already mentioned, as of now, you can go out and purchase as many firearms as you want from any retail store. As far as the litigation is concerned, what's the path forward for there? And, they mentioned B&L Productions. You mentioned ancillary rights. What's the outlook on that argument going forward?
So for Nguyen v. Bonta, what's going to happen now is the stay is lifted. I'm not sure if you can go right now and get multiple guns because it's a matter of gun stores being informed of this. You might go to a gun store and they're not aware what you're talking about. So we're doing our best to get the word out to them. But legally speaking, yes, you can. There's nothing preventing anyone from buying multiple firearms at once and then picking them all up, after their 10-day waiting period is done. For Nguyen v. Bonta going forward, we're going to eventually get a panel ruling. But I think there's at least a good chance this is going to be a 3-0 because even though, it was a favorable panel, there were 2 Trump appointed judges, but there was 1 Obama appointed judge, and he notably did not dissent from yesterday's order. He could have dissented and said, no, my other 2 colleagues are doing this, blah, 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 I disagree. He didn't. And at the oral arguments, he didn't seem very convinced by the government either. So whatever his reservations about the Second Amendment, clearly he thinks this law is dumb, So I think even this goes too far even for some gun skeptical judges because it is a silly law. So we'll see. In theory, the state could go to the Ninth Circuit en banc and ask them to put the stay back in place. They might. I mean, maybe they'll try that. But given that even the Obama appointed judge did not dissent, that might be a tough argument for them to make, and I think it'll seem a little silly for the Ninth Circuit to do that, but never put anything past the Ninth Circuit. That said, as of now, if I were a betting man, I'd say this will probably be left in place until we get our ruling, and then we'll see what the state does. This could be a lawsuit they decide not to pursue any further. We'll see. Now, as for B&L Productions, the panel yesterday in their questioning and the attorney for the plaintiffs did a good job explaining why, even with the tougher standard of B&L Productions and this whole ancillary right thing, the Nguyen plaintiff should still prevail, even under that tougher standard. But that said, my colleagues, it's not a case I've personally worked on, but my great colleagues, Anna Barvier, working with Don Kilmer, representing SAF, have filed an en banc petition to challenge the panel ruling in B&L Productions. And if you guys recall, that was a very tough 3-judge panel in B&L, even by Ninth Circuit standards. It was a 3-0 anti-gun panel. So maybe we'll get a better ruling en banc if they decided to take the case. And then, of course, if they don't decide to review it, they can also petition to the Supreme Court, which I'll let them talk about when the time comes, should it come to that. But yeah, so hopefully B&L is not final, but that's the basic summary of where those 2 cases are going forward.
Well, definitely a couple of things to keep up with as we keep up with all of this other litigation. Kostas, I know you're a busy guy with all of that litigation, but I want to thank you for coming on and sharing with us today.
No problem. Always a pleasure, Kevin. Thanks for having me.
Absolutely. And guys, if you like this content, you want to see more of it, please like, share, and subscribe to the video. The like button is really helping the algorithm these days, so if you could smash that, I would greatly appreciate it. It's a way for you to directly contribute to the litigation efforts and the legislative efforts on behalf of gun owners in the state of California. I want to thank you guys, and we'll see you on the next one.